exercise of the right of self-defense in response to an armed attack, provided that the use of force is exercised in accordance with the conditions attached to this right. The substantive customary conditions are necessity and proportionality, in addition to the procedural condition contained in Article 51 to notify the Security Council of the actions taken in self-defense. In the advisory opinion on the legality of the threat or use of nuclear weapons, the Court noted, inter alia, that proportionality and necessity are inherent in the very concept of self-defense. So, if the placement of a territory under the control of an armed force is the result of a military operation in the exercise of the right of self-defense, necessity requires an assessment of whether the occupation and the continuation thereof is necessary to repel the armed attack or that alternative courses of action are available. This inherently supposes also a temporal element of immediacy. If the right of self-defense is not exercised relatively promptly, it may imply that the exercise of the right of self-defense was unnecessary. Furthermore, with regard to proportionality, the question is whether the occupation and the continuation thereof is proportionate in relation to the armed attack, both in qualitative and quantitative terms. If that is not the case, the occupation may be considered to violate the prohibition of the use of force. These conditions to the exercise of the right of self-defense apply as long as there is an occurring or imminent armed attack. Also, in exercising the right of self-defense, the occupying state must fully respect international law, in particular human rights and international humanitarian law. Mr. President, it is the view of the Kingdom that the right of self-defense can also be invoked in response to an armed attack by a non-state actor. This is illustrated, for example, by the Security Council's resolutions adopted after 9/11, in which the Security Council reconfirmed the right to self-defense in response to those attacks. An occupation which fulfills the requirements of the right of self-defense may be considered as lawful under jus ad bellum. An occupation which does not fulfill or no longer fulfills these requirements may lose its legal basis and hence violate the jus cogens prohibition of the use of force. Finally, the Kingdom underscores that occupation is an inherently temporary use of force, because if it were to be permanent, it would qualify as annexation. As the Security Council emphasized in 1967, in its unanimously adopted Resolution 242, the acquisition of territory by war is inadmissible. The Court recognized the customary status of the illegality of territorial acquisition resulting from the threat or use of force in the advisory opinion on the construction of a wall. Mr. President, the Kingdom now turns to international humanitarian law, or jus in bello, which regulates situations of armed conflict, including occupation. According to the Court, and I quote, "A great many rules of humanitarian law applicable in armed conflict are so fundamental to the respect of the human person and elementary considerations of humanity," end of quote, "that they are," and I quote, "to be observed by all states, whether or not they have ratified the conventions that contain them, because they constitute intransgressible principles of international customary law," end quote. In the Court's view, these rules incorporate obligations which are essentially of an erga omnes character. The Kingdom considers these principles, furthermore, to be a peremptory norm of general international law, and would like to refer in this respect to the conclusion of the International Law Commission to include the basic rules of international humanitarian law in its list of rules of jus cogens. The Kingdom submits that while international humanitarian law is applicable in situations of occupation, international humanitarian law does not contain rules for determining whether an occupation is lawful or unlawful as such, even if breaches of the rules are serious in nature. Rather, irrespective of its legality, international humanitarian law regulates situations of occupation once such a situation has arisen in fact. As noted by the court, and I quote, "Under customary international law, territory is considered occupied when it is actually placed under the authority of the hostile army, and the occupation extends only to the territory where such authority has been established and can be exercised," unquote, as reflected in Article 42 of the Hague Regulations of 1907. As stated before, inherent in occupation is its temporary nature. Under the Hague Regulations, the occupying power shall be regarded only as administrator or usufructuary. After the Second World War, the Fourth Geneva Convention further developed the law of occupation by significantly enhancing the protection of civilians in situations of occupation. As noted by the court, the intention of the drafters of the Fourth Geneva Convention was to protect civilians who find themselves, in whatever way, in the hands of the occupying power. Furthermore, the drafters of the Fourth Geneva Convention sought to guarantee the protection of civilians in time of war, regardless of the status of the occupied territories. Once an occupation has factually occurred, the occupying power is obliged to act in accordance with the law of occupation. The occupying power has to respect and protect the civilians in the occupied territory who are regarded as protected persons. Protected persons are, inter alia, entitled in all circumstances to respect for their persons and shall at all times be treated humanely. Private property is to be respected. At the same time, such measures of control and security may be taken by the occupying power in regard to protected persons as may be necessary as a result of the war. As noted before, no sovereignty can be established over occupied territory, and occupied territory may not be annexed. In this regard, an important provision under the law of occupation is that the occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies. Under international criminal law, such transfers, directly or indirectly, by the occupying power, constitute a war crime, as reflected in the Rome Statute of the International Criminal Court. It is also prohibited to deport protected persons from the occupied territory. The Kingdom underscores that all high contracting parties to the Geneva Conventions are under an obligation to ensure respect for the Geneva Conventions with reference to Article 1 common to those conventions. As noted by the court, and I quote, "Every state party to that convention, whether or not it is a party to a specific conflict, is under an obligation to ensure that the requirements of the instruments in question are complied with," unquote. Mr. President, in relation to international human rights law, the Kingdom would first note that this body of law continues to be applicable during situations of armed conflict, including occupation. The Court has come to this conclusion in its advisory opinions on legality of the threat or use of nuclear weapons and construction of a wall. It added, in the case concerning armed activities on the territory of the Congo, that, and I quote, "International human rights instruments are applicable in respect of acts done by a state in the exercise of its jurisdiction outside its own territory, particularly in occupied territories," end of quote. The International Law Commission has equally concluded that human rights treaties continue to apply during armed conflict, in its 2011 draft articles on the effects of armed conflicts on treaties. It follows that an occupying power, for the purposes of international humanitarian law, is bound to respect, protect, and fulfill the human rights of all those within the occupied territory. The obligations owed by states under rules of universally applicable customary international human rights law are of an erga omnes character. The court has confirmed this in the Barcelona traction case, considering that erga omnes obligations, and I quote, derive, for example, in contemporary international law from the principles and rules concerning the basic rights of the human person, unquote. According to the court, this includes the prohibitions of genocide, slavery, and racial discrimination, as well as the prohibition of torture. Certain rules of international human rights law can moreover be characterized as peremptory norms of international law. According to the International Law Commission, this includes the prohibition of genocide, the prohibition of torture, the prohibition of slavery, and the prohibition of racial discrimination and apartheid, as well as the right of self-determination. Mr. President, both questions before the court concern the legal consequences of ongoing violations of rules of international law. Several of these rules are, as indicated, peremptory norms of general international law. As we have stated before, all such peremptory norms are applicable erga omnes. I will now address the additional legal consequences for all states and international organizations in the event of a serious breach of such a peremptory norm. It being noted that these consequences are additional to the regular obligations arising from the commission of an internationally wrongful act. The rules on the legal consequences for states when a serious breach of a peremptory norm occurs are reflected in Articles 40, 41 and 48 of the Articles on the Responsibility of States for Internationally Wrongful Acts. The relevant provisions for states and international organizations may be found in Articles 41, 42 and 49 of the draft Articles on the Responsibility of International Organizations. According to the Kingdom, these provisions reflect customary international law. These legal consequences may be divided in two categories: substantive consequences and procedural consequences. I will only address the Articles on State Responsibility in my statement. However, it is equally applicable to the draft Articles on the Responsibility of International Organizations. Article 40 of the Articles on State Responsibility defines a serious breach as a gross or systematic failure by the responsible state to fulfill its obligation under a peremptory norm. Article 41 stipulates the particular substantive consequences of such a breach, not only for the responsible state, but for the international community as a whole, including that state. In sum, states shall cooperate to bring the serious breach to an end, shall not recognize as lawful a situation created by such breach, and shall not render aid or assistance in maintaining the situation. The Court has confirmed the binding nature of the rules reflected in Article 41 in jurisdictional immunities. The Court has on multiple occasions pronounced on the legal consequences of serious breaches of norms affecting the international community as a whole. In Barcelona Traction, the Court established that obligations owed towards the international community as a whole are the concern of all states, and that, and I quote, in view of the importance of the rights involved, all states can be held to have a legal interest in their protection. They are obligations erga omnes, end of quote. The Court further confirmed these obligations in its advisory opinions on Namibia, the construction of a wall, and the separation of the Chagos archipelago. Thus, the jurisprudence of the Court supports the obligations reflected in Article 41 of the Articles on State Responsibility. The Court has also identified the obligation of non-recognition and the prohibition to render aid and assistance, and the obligation to cooperate to bring the consequences of the serious breach of a peremptory norm to an end. As to the specific implementation of these rules, the Kingdom observes the following. First, the obligation to cooperate to bring to an end the consequences of the serious breach of a peremptory norm will, in most cases, and particularly in cases concerning self-determination and decolonization, be implemented most effectively through the United Nations. However, should cooperation in the context of the United Nations fail to materialize, or should the United Nations be unable to take appropriate action, states are not relieved from their obligation to cooperate to bring the consequences of the breach to an end. In that case, they are obliged to seek cooperation through regional or bilateral fora. Second, the obligation not to recognize as lawful the situation brought about through the serious breach of a peremptory norm must take into account the exceptions to that rule as formulated by the court in the Namibia advisory opinion. Third, the rendering of unlawful aid and assistance contrary to the prohibition thereto does not give rise to international responsibility of the aiding or assisting state for the underlying situation or internationally wrongful act, but only for its unlawful aid or assistance. Fourth, the obligation not to render aid or assistance includes an obligation not to undermine measures, including sanctions, taken by other states in their endeavor to bring to an end the serious breach of a peremptory norm. In particular, when the state undermining those measures does so knowing that its conduct contributes to the maintenance of the unlawful situation. Finally, it is our view that a serious breach of a peremptory norm entitles states, other than the injured state, to take a countermeasure against the responsible state as a legal consequence of that breach. Such resort to countermeasures by a non-injured state must be in accordance with the customary rules on countermeasures, including the conditions of proportionality and reversibility. As a final observation, it may be recalled that the Kingdom considers that all peremptory norms are applicable erga omnes. Therefore, the procedural legal consequence of a serious breach thereof is that all states and international organizations have legal standing to invoke responsibility for such a breach. They may claim cessation of continuing internationally wrongful acts, assurances and guarantees of non-repetition, and performance of the obligation of reparation. A claim concerning reparation is restricted in the sense that it must be in the interest of the injured state or international organization or of the beneficiaries of the obligation breached. And such beneficiaries may include individuals and peoples. Mr. President, this brings me to the end of my statement. We sincerely hope that your advice will contribute to achieving peace in the Middle East. Thank you, Mr. President.
I thank the delegation of the Netherlands for its presentation. I invite the next participating delegation, Bangladesh, to address the court. Let me call upon His Excellency, Mr. Riyaz Hamidullah, to take the floor.
Mr. President, members of the court, it's my distinct honor and privilege to address the principal judicial organ of the United Nations on behalf of the People's Republic of Bangladesh and participate in these advisory proceedings on the legal consequences arising from the policies and practice of Israel in the occupied Palestinian territory, including East Jerusalem. Bangladesh fought for 23 long years to gain her independence and finally achieved it through a bloody war in 1971, during which 3 million people had to sacrifice their lives. In the early days of independent Bangladesh, in 1972, our father of the nation, Bangabandhu Sheikh Mujibur Rahman, said, I quote, "The world is divided in two parts, oppressors and oppressed, and I am with the oppressed," unquote. As Bangladesh pursued her own self-determination, our constitution mandated us to support oppressed peoples worldwide who are fighting imperialism, colonialism, or racism. This duty is outlined in Article 25C of our Constitution. In accordance with this duty, Bangladesh is participating in these advisory proceedings to contribute to the realization of the right of the Palestinian people to self-determination. We aim to achieve this by providing this court with our perspectives on the questions asked by the UN General Assembly in the current request for an advisory opinion. Bangladesh has long reiterated the call to end Israel's occupation of Palestine and to achieve a lasting and permanent solution which entails the establishment of a sovereign and independent Palestinian state along the pre-1967 borders, with East Jerusalem as its capital. We firmly believe that the court must heed the long overdue call to holistically examine Israel's occupation and render an opinion on the legal status of the occupation as a whole. As we heard in this very hall just last month, Gaza has been described as a living hell. On 20th May 2021, even before the ongoing war, Mr. Antonio Guterres, the UN Secretary General, said, I quote, "If there is a hell on earth, it is the lives of children in Gaza," unquote. I stand before the court also in the context of the fast developing circumstances in Rafah, with grave humanitarian implications for the 1.4 million Palestinian people, nearly half of them children. The ongoing war represents one of the most shameful catastrophes in the history of the modern era. The UN agencies and other humanitarian aid organizations on the ground have warned of a humanitarian disaster engulfing the tiny enclave of 2.3 million people with shortages of food, fuel, drinking water, and medicines worsening by the day. The killing of thousands of innocent civilians, particularly children, the destruction of their homes, the occupation of their ancestral lands, and the deliberate obstruction of their access to food and water all constitute blatant violations of international law and serve as textbook examples of ethnic cleansing. Bangladesh firmly believes that an advisory opinion on the questions posed by the General Assembly would undoubtedly represent a critical and logical step towards ending the illegal occupation. The dismantling of this occupation would, in turn, address the root cause of Israel's violent subjugation of the Palestinian people. We elaborated on these matters and the underlying reasoning in our submissions before the court, Mr. President, on 24 July and 25 October last year. It is pertinent to recall that just 4 months back, the UN Special Rapporteur on the situation of human rights in the occupied Palestinian territories, Francesca Albanese, in her report, brought up several appalling facts. I would consider it apt to quote one pertinent aspect, and I would quote, "In the occupied Palestinian territory, the fundamental right to life is under threat, as indicated by the mortality rates of Palestinian children. The neonatal mortality and infant mortality rates in the occupied Palestinian territory are respective 9.3 and 12.7 per 1,000 live births, rising to 14.8 per 1,000 live births for children under 5, while in Israel they are 1.7, 2.7, and 3.4 per 1,000 live births. In addition to direct attacks on the right to life, Palestinians also endure structural violence and racial discrimination, which impedes their full development," unquote. These structural violence of the occupation and the deliberate and excessive use of force against the Palestinians are indeed not limited to the recent events in Gaza. As the Special Rapporteur, Ms. Albanese, stated in her 2023 report, I quote, "The spectre of death looms as a dominant element in the lives of Palestinian children. This reality exerts a psychosocial toll on those who manage to survive, as pointedly expressed by Oadia, a 14-year-old girl. I quote, as she said, "Fearing death does not prevent you from dying, but it prevents you from living, unquote. Thousands of warriors keep crying in silence, deprived and disenfranchised for decades. Ending the occupation would necessarily bring an end to the violence that is exercised upon Palestinians on a daily basis. However, there is no end to the occupation in sight, nor is it likely to end through political means alone. It has become interminable. That much was all but confirmed by Israel's Prime Minister, Mr. Benjamin Netanyahu, on 18 January 2024. The court's intervention to us is therefore both timely and necessary. As I proceed with this oral statement, I wish to address whether the occupation of Palestinian territory by Israel is illegal or not. Even though the great majority of states participating in these proceedings, including Bangladesh, are firmly convinced that the occupation is illegal, we note that 2 states contend that it is not. Next, I will state the legal consequences that, in our view, derive from the illegal status of the occupation. On Israel's illegal occupation, Mr. President, members of the court, the fundamental question posed by the UN General Assembly regarding the legality of the Israeli occupation is grounded in established international norms and legal principles. The State of Palestine, in its written statement, underscores the colonial and acquisitive nature of the occupation, emphasizing its deleterious impact on the Palestinian people. The occupation, characterized by persecution, racial discrimination, and apartheid, stands in clear violation of 3 preemptory norms of international law: the right to self-determination, the prohibition of acquiring territory by force, and the prohibition of racial discrimination and apartheid. Numerous submissions have echoed these sentiments, highlighting the temporary nature of belligerent occupation as mandated by international law. The annexation of occupied territory and the settlement of the occupying power's nationals in the occupied area are explicitly prohibited, constituting illegal acquisition of territory under the UN Charter and relevant UN resolutions. Israel's prolonged occupation, coupled with its policies of colonization and annexation, underscores its illegality under international law. These actions not only contravene the UN Charter, but also violate general international law, including the preemptory norm prohibiting the acquisition of territory by force. Furthermore, arguments put forth by states and international organizations reject any justification for Israel's occupation on grounds of self-defense. The occupation violates fundamental principles of international law, including the right to self-determination and the prohibition of acquiring territory by force. The advisory opinion on Wall, which concluded that Israel cannot rely on self-defense to justify its actions, reinforces the notion that the occupation cannot be justified under international law. While the countries supporting Israel in these advisory proceedings have primarily focused on jurisdictional questions, a few states have addressed the merits of the occupation. One contends that an occupation can never be unlawful, regardless of violations of international humanitarian law. However, this argument stands in contravention of established legal principles and has been widely found to be incorrect. Switzerland's distinction between the law of occupation and the legality of occupation further elucidates the legal framework surrounding the issue. An occupation that involves annexation or de facto control of the occupied territory constitutes an illegal acquisition of territory by force as prohibited under international law. Ultimately, Israel's occupation, characterized by its acquisitive, colonial, and annexationist nature, represents a clear violation of international law. It serves as a means for the illegal acquisition of territory and must be brought to an immediate and unconditional end. I may also recall the UN Security Council Resolution 2334 of 23 December 2016, which reaffirmed the obligations of Israel, the occupying power, to abide scrupulously by its legal obligations and responsibilities under the 4th Geneva Convention in regard to the protection of civilian persons in time of war. That Security Council resolution also condemned all measures aimed at altering the demographic composition, character, and status of the Palestinian territory occupied since 1967, including East Jerusalem, including, inter alia, the construction and expansion of settlements, transfer of Israeli settlers, confiscation of land, demolition of homes, and displacement of Palestinian civilians in violation of international humanitarian law and relevant resolutions. Israel has flagrantly violated this and all other Security Council resolutions, and it continues to do so in furtherance of permanently maintaining its illegal occupation of Palestinian territory. At a more granular level, may I refer to the approaches of assessing legality advanced by the former UN Special Rapporteur, Michael Link, in his 2017 report to the UN General Assembly, and the current Special Rapporteur, Francisca Albanese, in her 2022 report. These are apposite and relevant to the Court's task in this case. The two approaches overlap and interrelate, but ultimately provide two pathways for determining the legal status of the occupation. I may humbly request the Court to consider the Link report, where he proposed a 4-part test for determining the legality or illegality of an occupation. The Special Rapporteur's approach also fits within the parameters of the Court's advisory opinion on the legal consequences for states of the continued presence of South Africa in Namibia. That opinion arose out of Security Council resolution declaring South Africa's continued presence in Namibia illegal. If South Africa's mandate could be found to be illegal due to its violation of the applicable international legal principles, so too can Israel's occupation by reason of its violation of the same principles. Therefore, applying one or both of these frameworks, which Bangladesh endorsed for the reasons stated in our written submissions, we respectfully submit that Israel's occupation is undoubtedly illegal. I would now turn on the legal consequences. Mr. President and members of the Court, there is a broad consensus that Israel, through its denial of the Palestinian people's right to self-determination, has violated preemptory norms of international law. These violations include persecution, racial discrimination, and apartheid against Palestinians, as well as the occupation, colonization, and annexation of Palestinian land. These systematic breaches severely undermine the rights of Palestinians as a people and Palestine as a state, while also hindering the prospects for a just and lasting peace in accordance with international law and relevant UN resolutions. Consequently, international law mandates the complete, unconditional, and immediate cessation of these internationally wrongful acts. All states and international organizations that have condemned Israel's conduct agree that these systematic and grave breaches carry legal consequences for Israel. As the responsible state, other states, and the United Nations and other intergovernmental organizations. So, on legal consequences for Israel, first, Israel must cease all acts preventing the exercise of the right to self-determination by the Palestinian people, including rescinding discriminatory laws and measures. This cessation includes withdrawing occupation forces, dismantling illegal structures such as settlements and the wall, and repealing annexation-related legislation. And secondly,